Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, law offices across and associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So we received an interesting inquiry here on our YouTube channel. This has to do with somebody who got accused of brandishing a knife. Let's see. I carried a knife in plain view hanging off my pants. There was a fight with some people, and I took it out simply to prevent an attack against me. I was arrested without even being involved in the fight. All right, well, it seems to me that if the DA were to charge you with something, although in my opinion they shouldn't, but if they were to charge you with something, because just because you were arrested doesn't mean that the DA will actually file the formal charges, but if in fact they did, they would probably go with a violation of Penal Code Section 417, which is brandishing, brandishing a weapon, in a dangerous manner, or in a threatening manner, rather. This would be a 417. It's a misdemeanor that carries up to 1 year in county jail. Now, here's the thing. One thing is if somebody, was fighting, you had nothing to do with it, and then you approach them with a knife in a threatening manner and say, hey, don't mess with me, buddy, or I'm about to attack you. Well, at that point, that's brandishing, but it might also be an assault, depending on the point of view. Could even be considered a 422, although it's conditional, which would be criminal threats. But if somebody is about to attack you, or it looks like they're looking toward you as if they're gonna attack you, and you say, hey, look, you pull it out and say, come on, I don't want trouble, just I'm staying out of this, that's a form of self-defense. At that point, if it really happened like that, in my opinion, they're kind of sort of grasping at straws, because you do have the right to use the minimal force necessary to prevent you suffering any kind of injury. And in this case, you're using zero force. You're simply just, hey, back away, it's cool. But see, it really depends on exactly how it happened. I mean, if somebody was in process of attacking you and you do that, that's fine. But if you're approaching people, you're going toward them like this, okay, now we're talking about brandishing, maybe assault with a deadly weapon, being the knife, because as you may or may not know, assault is putting somebody in apprehension of suffering an injury. It's not the actual impact itself. But yeah, in this case, I think if you looked at the raw facts, especially if there was some kind of video, enough witnesses to say, yeah, he didn't do any attacking, he was just backing away, he just wanted to be left alone, this should just go down to self-defense, and it really shouldn't even be charged. And if it does get charged, it should be dismissed. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices Across and Associates. And, you can ask questions in the comment section below, and we will respond in the future with more videos. But if you've been accused of a crime and need representation in court here in the San Francisco Bay Area, call us now for a free consultation at 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who got accused of a theft during a protest. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal lawyer, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.